Yes, Mr. Carroll.
Thank you, my Lord. Before lunch, I was addressing why this bankruptcy application still matters and the economic interests that flow from that. Now, continuing with those submissions, if I can invite the Court please to turn to the Court of Appeal's judgment from 3 weeks ago, which is in the supplemental hearing bundle at page 141.
Supplemental hearing bundle.
Well, there's supplemental authorities,
I
think, and this is supplemental hearing bundle. Now, this is the decision in the cottage eviction proceedings handed down 3 weeks ago. Now, this judgment is about one thing and one thing only, which is whether or not it was lawful for the appellant today, Chedington, to evict the Brakes from the cottage on the 18th of January 2019. Those proceedings proceeded on the assumption that the licence granted by Mr. Swift to Chedington was effective. The effectiveness of that licence was Chedington's sole defence to the cottage eviction proceedings. Chedington had no paper title and no prior possessory title. And Chedington argued that their licence for non-exclusive occupation from Mr. Swift as beneficial owner trumped the Brakes' legal title and factual possession. The Court of Appeal also found that Chedington was authorised by the trustee in bankruptcy, Mr. Swift, to take possession. If I could just show your lordships, that is at page 155. If I could invite the Court to read, please, paragraphs 55 and 56.
So Chedington drop out effectively, and the contest is as between the trustee and the Brakes.
Not quite. There are implications because of the need to assess consequentials in the eviction proceedings.
Yes, but as regards the contest between the interests, Chedington doesn't have any better interest than the trustee.
Oh no, that's right. That's absolutely right. Yes, my lady. Yes. Now, if I could invite the Court to jump back a few pages to page 145. And this is relevant to the discussion that took place before the short adjournment concerning the lack of a court order. If I could invite the Court, please, to read paragraph 15, starting at the bottom of page 145, and 16 over the page, please. And if I can invite the court now to turn ahead to page 163. And at paragraph 82, there's the court's conclusion that the eviction was unlawful at common law and that Chedington had no right or title at common law to justify any interference with the Brakes' exclusive possession of the cottage without a court order. And of course, Chedington did that as agent of the trustee. That's the conclusion of the Court of Appeal. Now, that conclusion means that on the face of it, the Brakes are entitled to an order for possession, but what else happens is heavily dependent on the lawfulness of the transactions entered into between Mr. Swift and Chedington, i.e. the matters that are before this court today. And I will now summarise the ways in which the issues before the court today, or the issues raised in the bankruptcy application, remain significant. Chedington contests the Brakes' right to damages for unlawful eviction on the ground that the Brakes have suffered no loss. Chedington has pointed out at trial in the eviction proceedings that since their eviction in January 2019, the Brakes have stayed in the far more comfortable West Axnoller house. But this is highly significant because the Brakes lost the house possession proceedings following a trial, and they have been ordered to pay mean profits to Axnoller Events Limited, i.e. Chedington's wholly owned subsidiary, the owner of West Axnoller House. Now, it would plainly be unjust if the Brakes were required to compensate Axnoller for their occupation of the house when they were in the house because they had been unlawfully put out of the cottage by an associated company under common control.
I'm sorry, I don't think those are the facts, are they? Because the finding that the judge made at first instance, which the Court of Appeal didn't interfere with, is that they were not residing at the cottage.
Yes, but they
were just in possession, as my lord said before the adjournment, because they had pieces of furniture and so on there.
Yes, but they had nowhere else to go once they were evicted from the cottage.
I thought you said they were living in the house.
They were never living in the cottage.
They weren't in the cottage when possession was taken.
Yes, but
the concept of them being thrown out is just not consistent with the facts. They weren't there. All there was some of their furniture.
May I just confirm? All right, the way the argument is put is that it wouldn't be just for mean profits to be paid by the Brakes for excluding Axnoller Events from the house in circumstances where the Brakes had simultaneously been excluded from the cottage.
I'm not following this, I'm sorry. I mean, they're required to pay mean profits for their occupation of the house because they're living there without having any other interest in it, isn't that right?
Yes, that's the.
Well, why would that not be the position if they lived in the cottage?
The submission is that the liabilities will essentially cancel each other out because they've been excluded from the cottage at the same time as Axnoller Events have been excluded.
They don't have a right. I don't think they have a right to live in the cottage, do they?
Well, they're in. They have a better right than anybody else.
No, they don't have a better right than anybody else. They have a better right than Chedington.
Yes, and Chedington was claiming its right solely under the right of Mr. Swift.
I mean, all this seems to show is that the gravamen of the dispute is all about entitlement to possession of the cottage and has nothing whatever to do with the bankruptcy. Apart from the fact that it arises out of the bankruptcy as a matter of historical background.
Well, in my submission, my lord, it's a very significant historical background in that Mr. Swift did what he did in his capacity as trustee in bankruptcy, and the Brakes suffered it in their capacity as bankrupts. It couldn't have been done
But
before the bankruptcy.
that's the point, isn't it? Did
Yeah.
they suffer it in their capacity as bankrupts? That's how do you make that good?
And how do you square it with what you told me before lunch, that it wouldn't have mattered if it wasn't them as bankrupts, but somebody else?
They're slightly different points, my lord. The latter point is addressing your lordship's observation that this was nothing to do with the bankruptcy, and it was to do with the bankruptcy by virtue of it having been done to the Brakes in their capacity as bankrupts.
But you'll seek to make good that submission that all this has been done to them in their capacity as bankrupt.
Yes, that is the third area of my submissions, which is looking at exactly what the trustee in bankruptcy did. The next aspect in which the matters raised in the bankruptcy application remain at large is in relation to what will happen to any damages payable by Chedington to the Brakes. This arises from a point raised by Lord Justice Lewison in the course of argument in the Court of Appeal. It's that if Mr. Swift was the beneficial owner of the cottage, then there may be an argument that the Brakes, as legal owners of the cottage, will hold any damages that Chedington has to pay on trust for Mr. Swift. And as Lord Justice Lewison identified, that could mean a security of action. But that assumes that the contractual arrangements that the Brakes challenge in this bankruptcy application are lawful and secure. And so whether or not these contracts entered into between Mr. Swift and Chedington were lawful and what consequences flow from that still has considerable ongoing significance for a number of parties.
Well, could that not have been decided in the eviction proceedings, insofar as it's relevant to those proceedings?
My lord, no. The appropriate place to deal with the regulation of Mr. Swift's conduct as trustee in bankruptcy is under Section 303 in the insolvency proceedings. It's questions of that kind about the conduct of office holders ought to be determined within a single set of bankruptcy proceedings.
But why wasn't the effectiveness of the licence an issue or potential issue in the possession proceedings? I mean, if the licence was invalid, then that would have been an answer to the claim for possession, wouldn't it?
Yes, the way it was run, the way the trial of the eviction proceedings was run was on the hypothesis that the licence was valid and the Brakes were not permitted by the trial judge to argue to the contrary, and that was because this bankruptcy application was ongoing. And I think that's paragraph 196 of the trial judgment in the eviction proceedings, which isn't in the bundle. But the judge said, words to the effect of, I need to proceed on the basis that the licence is valid and effective because the bankruptcy application is extant.
I'm just looking at your damages point. You say there's a bankruptcy question about whether the Brakes would have to pay any damages they get under the eviction proceedings to the trustee, which would presumably be the current trustee, not Mr. Swift. But anyway, never mind which trustee it is, to the trustee. Is that really the issue? I mean, and you say that arises because you're challenging not merely the licence, but the transaction by which the trustee in bankruptcy became beneficial owner.
Quite so, my lord, yes.
And that was a transaction between the trustee and the liquidator, which had previously been the beneficial owner, as I understand it, or the liquidation estate had been the beneficial owner. So isn't the only damages question who, as between the liquidator and the trustee, should receive those damages? It being common ground, as I understand it, that the breaks are nothing more than bare legal owners, and that's what they've ever been since the liquidation started.
My lord, I'll come back to that if I may.
Okay.
I don't have an immediate answer, but we'll give that some thought. So, my lord, moving on now to the third area of my submissions, which is looking at what the trustee in bankruptcy actually did, and this makes good the Breaks position that what happened to them happened in the bankruptcy sufficiently that they can have standing under Section 303(1). Now, in summary terms, the Breaks case is that Mr. Swift hired out his statutory powers to Chedington, which was a stranger to the bankruptcy, not a creditor. He used his powers as trustee in bankruptcy for the improper purpose of assisting Chedington with his private dispute with the Breaks. And he entered into agreements with a view to giving Chedington the power to evict the Breaks from the cottage. And this discloses a lapse in objectivity by the trustee in bankruptcy and a loss of independence. Now, I should like to show the court the contractual arrangements themselves, starting with the facilitation agreement, which is in the supplemental bundle at page 170.
I'm sorry, which bundle?
This is the supplemental hearing bundle, my lord.
Right.
10th of January.
It's a letter from Moore Stevens.
Yes, that's right. Yes, this is the document that's described as the facilitation agreement. It's dated 10th of January 2019. It was addressed from Moore Stevens to Dr. and Mrs. Guy, and it's headed Facilitation Support of the Trustee in Bankruptcy of Mr. AY and Mrs. NMK Brake, who are defined there as the capital D debtors. So straight away, the ambit of this document is that the trustee in bankruptcy is doing something, and it's in relation to the Breaks as capital D debtors. If I could invite the court, please, to read paragraph 3 on that page under the heading Consulting Services. And the aspect of that I'd particularly invite the court to note is the reference in the fourth line to an office holder application to court. Now, in my submission, it is very clear from the employment of that language that the trustee in bankruptcy is talking about doing things for Chedington in his capacity as trustee in bankruptcy. It further refers to Appendix 2, which we'll look at in just a moment. Then over the page, at page 171, paragraph 7, under the heading Facilitation Price and Funding, it reads, the facilitation price for this assignment is as detailed at Appendix 2. It comprises two parts, one part being our fees for undertaking the services referred to above, the other part being the benefit to the debtor's bankruptcy estates. So again, the trustee in bankruptcy is effectively selling services as trustee, and the fee is being split between a private fee for the trustee's firm and the element of the fee that is accounted for to the bankruptcy estates. If I can invite the court to turn ahead to page 173, please. This is Appendix 1, and it sets out terms of business of a kind that one would usually expect to see in a professional engagement between a professional and a client. And the aspect that I'd invite the court to note is the 3 paragraphs up from the bottom, reference to confidentiality. And so the trustee in bankruptcy is entering into a confidential retainer with a stranger to the bankruptcy estates. Then if the court would be good enough to turn ahead to page 176, where we find Appendix 2, which is really the heart of the matter. The third bullet point, or firstly, the first bullet point provides for Chedington to put the trustee in funds in order for the trustee to acquire the interest in the cottage from the liquidators. And then the second bullet point provides for a back-to-back sale, which it's proposed will take place immediately. And the third bullet point refers in the first sentence again to the back-to-back sale. And then critically, in the third sentence, it reads, it should be made quite clear that the trustee in bankruptcy will therefore not receive any direct benefit to the bankruptcy estates other than the facilitation price, the details of which are below. At the same time, an immediate licence to occupy will be granted by the trustee in bankruptcy for the cottage to be used by Chedington as necessary, and such licence will oblige Chedington to bear all necessary insurance obligations from the licence. The fourth bullet point provides for the time frame to be as soon as possible in order to provide Chedington with the licence to occupy in advance of the hearing on 17th of January 2019. Now that was a hearing in the house possession proceedings, which was not something that the trustee in bankruptcy should have been concerning himself with. So the third and fourth bullet points together provide for the trustee in bankruptcy to enter into a transaction to acquire a property in relation to which the estate will not receive any direct benefit on a time frame that is dictated by something that's happening in the house possession proceedings. The fifth bullet point provides for the trustee in bankruptcy to make an application to court. And this application to court is to gain clean registered title to the cottage, and then it goes on to say, and deal with all of the inevitable issues that the debtors will try and pursue. In other words, the liquidator does not need to feature in this process, which may be one of his concerns. Now, pausing there, the reason that the Guy parties didn't buy the interest in the cottage directly from the liquidators is because the liquidators were reluctant to get involved with proceedings to regularise the title, which may have been a sensible position for them to adopt. So that's what that's a reference to. The bullet point continues, further, to the extent the debtors argue an ownership interest, it was one that would have vested in the trustee in bankruptcy when appointed, and as they did not disclose it as an asset in their estates, it should successfully end any argument on that front. The trustee in bankruptcy will also, in that application, seek to close down the extant High Court proceedings, so one set of proceedings to deal with all 3 points. The 6th bullet point provides that Chedington will therefore receive registered title free of any possible claim by the debtors and free of the charging order in favour of PWF, the LLP. Chedington will also help the trustee in bankruptcy close off the High Court proceedings, so Mrs. Bream and PWF need not be concerned about that threat going forward. Now, in my submission, what we have in those bullet points is a situation where a trustee in bankruptcy is, for a fee, taking sides in a bilateral dispute involving the bankrupt and a stranger to the estate. This contractual arrangement refers to the Brakes as capital D debtors and to Mr. Swift as TIB. Plainly, Mr. Swift is acting as trustee in bankruptcy, and he regards the Brakes as the bankrupts for the purposes of this contractual arrangement. And the consequence of that, in my submission, is that it's difficult to take seriously the proposition advanced by Chedington on this appeal that what was done here to the Brakes was external, as they deploy that word, to the bankruptcy. They are referred to as debtors, and the trustee in bankruptcy is explicit that he is doing these things in his capacity as trustee in bankruptcy. The debtors are characterised by the trustee in bankruptcy and Chedington in this agreement as adverse counterparties who are the targets of these arrangements. The final section on page 176 deals with legal costs for which Chedington will indemnify the trustee in certain terms. And then over the page 177, under the heading facilitation price, there's discussion of the fee. And it says, the trustee in bankruptcy must demonstrate a suitable benefit to creditors in order to proceed as set out above. So a facilitation price will be paid by Chedington to the trustee in bankruptcy in the following sums. And then it provides for a £30,000 payment at the point of instruction and then a £3,000 a month retainer. Jumping down to the next main bullet point, it provides that the facilitation price is to be applied in a certain way. I'm looking at the sub-bullet points there. It provides that 1/3 will be made available to the creditors in the bankruptcies of the capital D debtors, and then 2/3 will be paid to the trustee in bankruptcy to allow the trustee in bankruptcy to spend the necessary time on these matters as it progresses without that being a cost to the bankruptcy estates and therefore the creditors in the two bankruptcy estates. So he's getting a private retainer with a stranger to the bankruptcy to act in his capacity as trustee in bankruptcy.
Isn't that to the benefit of the creditors, because the creditors are not then having to bear the cost of that from the estate?
It should nonetheless be accounted for to the bankruptcy estate. The trustee in bankruptcy, as a fiduciary office holder in a highly regulated statutory regime, should not be entering into private retainers at all, and certainly should not be arranging a private fee arrangement with an instructing party separately to the bankruptcy estate. And there's a very curious provision in the final bullet point under facilitation price where it reads, any sums paid in relation to the facilitation price by Chedington shall be subrogated to the bankruptcy estates and will be repaid pari passu in accordance with the Insolvency Act following any subsequent recoveries made in the bankruptcy estates. And it's far from clear what that is supposed to mean, who they are sharing pari passu with, and which provision of the Insolvency Act that is said to be in accordance with. The final paragraph on that page reads, separately, it is the trustee in bankruptcy's understanding that Chedington has indicated a willingness to consider financial support in circumstances where claims are brought by the debtors or others supporting them against the trustee in bankruptcy This indication is as part of the overall plan of working together in dealing with the issues created by the debtors and their associates. Such requests will be considered on a case-by-case basis by Chedington, and that indication is greatly appreciated. Now, in my submission, that evidence is a serious loss of objectivity by the trustee in bankruptcy, and this arrangement certainly crosses a line. It represents a surrender of objectivity and a contract to act for improper purposes that is something that should interest the court and ought to be examined. The proper purpose of bankruptcy is to get in, realise and distribute the bankrupt estate in accordance with the Insolvency Act, and in doing that the trustee in bankruptcy is entitled to use their discretion, but they are not entitled to surrender it, and they must retain their objectivity, and that hasn't happened in my submission here. If I could show the court now the bankruptcy sale agreement as it's been defined, and for this we'll need to go back to the core volume. It's page 270 of the core volume.
Just before you do,
Yes.
the bit of all this in which the trustee's participation, or Mr. Swift's participation, might have been facilitated by his being a trustee in bankruptcy, as far as I can see, is just that if the Brakes claimed some beneficial interest in the cottage, Mr. Swift will be able to say, well, that vested in me when they went bankrupt.
Yes.
Nothing else that he's doing here seems to be in any way assisted by powers conferred, special powers, other than merely what arises from ownership of property under back-to-back sale agreements, conferred by the legislation.
Yes, matters didn't progress to the stage where the trustee in bankruptcy was deploying.
Well, that's the only bit of deployment I can see being hinted at here.
Yes, well, it's I respectfully submit, my lord, is rather more than a hint. It's an express agreement to go off and make an application to court wearing his hat as trustee.
If the Brakes claimed a beneficial interest in the cottage.
No, my reading of these arrangements, my lord, is that Mr. Swift is going to regularise the title for Chedington. That's the whole point of the onward sale.
Oh, I see. Yes, okay.
So
But isn't the idea that it's not clear before this transaction who owns what part of the beneficial interest in the cottage? The partnership says it owns it, and therefore liquidators own it, and they're selling that, if any, to Mr. Swift. Mr. Swift, as my lord says, owns whatever interest the Brakes have under the alleged agreement that they reached, they say, which is the subject of the High Court proceedings. So nobody knows what the balance is between those two sets of rights. But if they're both then in Mr. Swift, by him buying the rights from the partnership, liquidators, and he already has whatever rights the Brakes have, then he can go to court and say, well, I've obviously got all the title now and I want to sell it to Chedington's. Isn't that what was happening here?
there may well, my lady, have been a way that Mr. Swift could have done this properly in a way that would have benefited the bankruptcy estate and not.
Well, how else can he monetise whatever value the rights that he acquired from the Brakes, whatever rights they have that they were seeking to vindicate? He could pursue those proceedings, or he could gather up all possible rights that there are and then sell those to someone else.
Yes. My lady, the arrangements that Mr. Swift actually entered into were not arrangements that were directed at getting the rights together for the purpose of realising them for value for the bankruptcy estate.
Why do you say that?
Because one shouldn't look at any part of this arrangement in isolation. The facilitation agreement is part of, and we've just looked at the bullet points providing for what the objects of this are to enable Chedington, by means of a licence, to get the brakes out of the cottage within a couple of days by reference to the date of an application hearing in the house possession proceeding. It's telling that Mr. Swift paid, using borrowed money that he'd borrowed from the Guy parties, paid £500,000 to the liquidators for whatever right the liquidators had, and then contracted to sell clean title for exactly the same amount of money. So it's not...
Well, except for the part of the £36,000 that went to the estate.
Yes, except for a pretty nominal £10,000 fee for doing a great deal of work. In circumstances where he acknowledged in Appendix 2 that there is no direct benefit to the estate from the acquisition of this property.
Well, other than the fee?
Yes, other than a pretty nominal fee.
But do you know that the rights that he acquired from the brakes that they were asserting in the High Court proceedings were worth more than the estate got out of this series of transactions?
That's really part of the mischief here, is that Mr. Swift didn't accept that there were any such rights. No. Mr. Swift's position was that it was all trumped up.
Yeah. So whatever money he got for the estate was quite a good deal then.
My lady, I would submit that £10,000 for what went on is not a good deal for the estate.
But that's not the gravamen of your complaint, is it? And you're not in a position to make that complaint, because even if it was worth more, you wouldn't get any of it.
No, that's right. That's right. The gravamen of the complaint, my lord, is the nature of the arrangements were targeted at the brakes as bankrupts to get them out.
Well, when you say they were targeted at the brakes as bankrupts, are they not actually targeted at the brakes as people claiming a right to possession, as has been held they had, of the cottage?
It's evident from Mr. Swift describing them as debtors and describing himself as trustee in bankruptcy of those debtors that he regarded them as bankrupts. And had they, the bigger point here is that had they not been bankrupts and had Mr. Swift not seen himself as in an adversarial relationship with the bankrupts, Mr. Swift wouldn't have been dealing with them in that way.
I mean, I accept entirely that everything Mr. Swift did here, he did as trustee in bankruptcy. He didn't have any position other than as trustee in bankruptcy, and he didn't have any powers to do at least some of the things that he was going to do. So that much is clear. But if the focus is on the brakes, I mean, it may be your case, and in answer, one of the answers you gave just before the adjournment this morning is that it doesn't really matter whether or not this was adverse to the brakes in their capacity as bankrupts. But at the moment, I have difficulty in seeing that it's really directed to them as bankrupts.
It is difficult to delineate where a person is bankrupt and their trustee in bankruptcy is entering into contractual arrangements to affect their existing rights. To delineate between things that are done to them as bankrupts and things that are done to them not as bankrupts, where the person doing the thing is their trustee in bankruptcy, who to the best of everyone's knowledge wouldn't have had any dealings with them had he not been their trustee in bankruptcy. He was not known to.
That's why I sought to identify what it was that was bankruptcy related in all this. The only thing I've been able to identify is that if the breaks, quite apart from being there in possession, which was something that Chedington and the liquidator and Mr. Swift wanted to deal with, also asserted a beneficial interest, then the fact that they were bankrupts meant that that beneficial interest vested in the trustee. But their mere status of being there in possession didn't have anything to do with them being bankrupt, did it? I mean, it would have been just as much of a problem for the parties who wanted to get clean title to the cottage as if some complete stranger had been squatting there.
That's right, my lord. But the scheme of this contractual arrangement that the trustee entered into was that he would make an office holder application to the court against the breaks in relation to regularising title to the cottage. And it is the contemplation of making an office holder application against persons who are bankrupts and in relation to who he is the trustee in bankruptcy that means it was, in my submission, done to them in their capacity as bankrupts. It's unreal to in my submission to suggest that it was done to them in any. It could have been done to them in any other capacity. It was an application made. It was to be an application made in the bankruptcy.
So you say effectively what sauce for the goose is sauce for the gander.
Quite so.
If they were contemplating making an office holder application against the breaks, why can't the breaks anticipate that by making their own application into bankruptcy to stop it?
Precisely so, my lord.
Yeah.
Yes.
Well, they would have been able to resist it, I suppose, wouldn't they? I mean, they would have had to be parties to the application.
Yes.
Yes.
Yes. I mean, the Court of Appeal.
Court of Appeal wondered why the trustee hadn't gone ahead and taken the steps and said if they had, we wouldn't have been here.
Precisely, yes. And it is because in the breaks case, he lost his objectivity and he made some serious errors, and they're errors of a nature that the court ought to be interested in.
Well, but that all depends on them being raised by a person with a proper interest in raising them. I mean, the court doesn't have a roving commission of inquiry. That's the point that Lord Millett made in the Deloitte case.
Yes, but
it comes back to the same point.
It comes back to the same point, in my submission, it cannot be right to run the case that the appellant is running, which is that it is open to a trustee effectively to do whatever he wants, act beyond powers, act for improper purposes, and unless it causes loss to the estate, in which case a creditor could challenge it, no one can ever challenge that kind of conduct.
Well, they can actually, can't they? Because, I mean, in order to be a trustee in bankruptcy, you have to be a licensed insolvency practitioner, don't you?
Yes.
And that's a regulated profession.
It is. Yeah.
So, if a trustee in bankruptcy is behaving in a manner they shouldn't behave, then that, in terms of policing it and that sort of thing, that can be done through the regulatory process.
Not sufficiently so, my lord. The arrangements that are challenged here are contractual arrangements that the.
But you say that the trustee lost his objectivity, was involved in conflicts of interest and so on. These are all criticisms that you make, presumably based on the duties of a trustee in bankruptcy. If there's been a breach of duty, breach of professional standards, then that can be the subject of regulatory investigation.
It could be the subject of regulatory investigation, but it wouldn't have the kind of consequences that are pleaded as the relief sought by.
No, I follow that.
Yeah.
I follow that. But it was more trying to deal with your point about this is something the court ought to be interested in and shouldn't tolerate and so on.
What about
sounds
section
like a
304? Isn't that available as well as if trustees misbehave?
Yes, that's where that's a misfeasance provision. So that is where a loss is occasioned by a breach of duty, and it doesn't arise on the fact of this case, and it is a quite different form of relief. That's a misfeasance provision, and Section 303 is a regulatory provision it's about effectively policing conduct of its own officers by the court.
Right. Well, because nobody's been harmed by the conduct.
The estate has not been diminished in a way that I didn't plead the case and came to it quite late on, but I would submit that this isn't a Section 304 category of case. We are in the of regulating the trustee's conduct and challenging acts, omissions, decisions of the trustee rather than accusing him of having committed misfeasance of the kind falling within Section 304. So if I could show the court the bankruptcy sale agreement, which is at page 270. And the court will note that in large block letters it says contract for the sale of property by a trustee in bankruptcy, which again makes it hard to argue in the submission that this didn't happen in the bankruptcy. At page 272.
So page.
Sorry, which bundle are we in?
What's the page?
Oh, I'm sorry. This is the core volume.
Right. Thank you.
And it starts at page 270.
270. Thank you.
And I've just turned on to 272, having introduced the document. At page 270, we see the heading contract for the sale of property by a trustee in bankruptcy. And then at page 272, it records the parties, and it records that Mr. Swift is acting as trustee, and it reiterates that at recital H. Recital C, it records that the trustee agrees to progress the court application as soon as feasible with expedition in order to procure a transfer of the legal and beneficial title of the property to the buyer within the contract period. Over the page, we see some defined terms. It's a conditioned precedent for completion of this that the court order, capital C, capital O, is received. And then contract period is defined as 24 months commencing on the date of the contract. Now, the contract period has expired, and this sale by Mr. Swift to Chedington has not completed and now never will. Over the page on page 274, clause 2.1 provides that subject to the conditions precedent, the trustee will sell and the buyer will buy the property for the purchase price on the terms of this contract. And then at 3.1, one of the conditions precedent is that the trustee agrees to make the court application as soon as reasonably possible and thereafter use best endeavours to procure the court order. So again, in my submission, that shows a surrender of judgment because he's binding himself to use best endeavours to make a court application in his capacity as trustee in bankruptcy for the benefit of someone else. And then finally in this document, if I could ask the court to turn to page 278. and look at clause 16.1, which provides that the trustee is acting solely in his capacity as trustee in bankruptcy for the bankrupts and will not incur any personal liability under or by virtue of this contract, nor in relation to any related documents, matters or claims whatsoever. Now, if I could show the court the licence, which is at page 281 of this bundle. This is the sole basis on which Chedington purported to evict the Brakes from the cottage in January 2019, and it's the sole basis on which Chedington defended the action for unlawful eviction. The Brakes pleaded cases that the licence was a sham, and it contains some hallmarks of that. If I could show the court some of the defined terms at page 283. In passing, I'd invite the court to note that the licence period is to be determined in accordance with clause 4, and it's common ground that it lapsed in 2021. And then permitted use. The permitted use is as a residential property. And over the page at 284, clause 2.1, it provides that the licensor permits the licensee, so that's Mr. Swift permits Chedington, to occupy the property for the permitted use in common with the licensor and all others authorised by the licensor. And then at clause 3.3 it provides that the property is not to be used other than for the permitted use. Finally, at clause 9 on page 287, it's again provided that the trustee is acting solely in his capacity as trustee in bankruptcy for the bankrupts, and the trustee has in fact executed this licence twice, once in his capacity as trustee for Mrs. Brake and once in his capacity as trustee for Mr. Brake.
Can you remind me what the permitted use was?
Yes, to occupy as a residential property. That's at 2.
Oh, I've got it. Yes, I've got it.
Now, if I could now show the court an extract from Mr. Swift's evidence in other parts of these bankruptcy proceedings, and that's in the key documents bundle at page 193. This is an extract from evidence that Mr. Swift gave on the 26th of October 2021.
What page? The key documents.
Yes, my lady, key documents, page 193.
And this is cross-examination in front of whom? Judge Matthews?
Judge Matthews.
Yes, I've got it.
Yes. The relevant passage is in the top left panel between lines 17 and 25. Mr. Swift says, "The only thing I would add is that the application for my removal was on the grounds of possible bias in favour of either Dr. Guy and or Mrs. Bream and or PWF. It's a bit like running a steward's inquiry in a horse race. It is quite right that a trustee's conduct be open to scrutiny by the court. So I agreed. I consented to be removed and replaced in order for that scrutiny to take place." So Mr. Swift, to his credit, has not sought to defend these matters, although it should be said that in his witness statement he has said that he still believes that what he did was the right thing. But nonetheless, he doesn't oppose the brakes issuing this application. The only party that seeks to stop the brakes ventilating these matters before the court is Chedington, which is, on any view, a party seriously adverse to the brakes and pursuing its own interests that are not any interest of the bankruptcy. So applying the same sort of source for the goose sort of analysis, Chedington is far more of a stranger to these bankruptcies than the brakes are themselves, because the brakes are, at least, the bankrupts, albeit not interested in a surplus. But Chedington has no interest of any kind at all, apart from being the defendant to the application that is brought by the brakes to challenge things that the trustee did in concert with Chedington. I should now like to move on to the fourth area of my submissions, which is the law.
So before we do that, what about
Yes.
the adjacent land? All this relates to the cottage, as I understand it.
Yes. May I just confirm, my lord? My lord, I'm told that the adjacent land issue has not formed the focus of attention before today. So we're sort of dealing with this on the hoof. I'm not formally conceding anything, but I can see that the adjacent land is in a slightly different category from the cottage.
But you are seeking, I thought, in your application to set aside the transfer of the adjacent land that was made in December 2018.
Yes, that is the case as pleaded, yes. So if I could move on now to submissions on the law. The grounds of the dispute here are actually quite tightly confined. Neither side has gone to the extremes that they could have done in formulating their case. So what I mean by that is that Chedington hasn't gone as far as to suggest that a surplus for the bankrupt is a necessary condition, which the judge at first instance appears to have thought to have been the case, although it's not absolutely clear. But that's certainly the way the Court of Appeal interpreted the first instance decision. We, the brakes, on the other hand, don't contend that a bankrupt has standing without more solely by virtue of the plain words of section 303(1), which on their face don't limit the bankrupt's ability to apply. Nonetheless, we agree that an additional filter is necessary, and we say that that filter is the legitimate interest or the substantial interest that has been adversely affected. And we say that the brakes satisfy that by means of their existing interest, by means of a possessory right to the cottage, and that possessory right was adversely affected. Now, we recognise that the court will naturally be concerned about the practical consequences of letting in too much if this appeal is dismissed, and this is the point that my Lady Rose raised before the short adjournment. The hazard is opening the way for bankrupts to bring time-consuming and unworthy applications. In my submission, dismissing this appeal would not have the effect of opening the floodgates to such applications. And in my submission, the court should be no less concerned today about excluding too much by allowing this appeal. Now, it's emphasised by the brakes on this appeal that their application was struck out by Judge Matthews solely on grounds of standing. i.e. that the breaks do not have the right to be heard at all. And the court, in my submission, should approach this case on a principled basis, bearing firmly in mind that this appeal relates solely to the breaks' right even to be heard, even to ventilate these grievances. And any general sense that the breaks are unattractive litigants should not feature in the court's analysis of the narrow point before it today. Now, in my submission, the court should not accept Chedington's invitation to prescribe an artificial exclusionary rule, i.e. their internal-external distinction, to shut out the breaks. And that would be a very high price to pay in order to avoid listening to the merits of their position. The cases show that the courts are well able to deal summarily with unmeritorious applications from bankrupts without resort to the kind of test favoured by Chedington. And Mr. Sutcliffe suggested that the cases I had identified in our written case where the standing point wasn't noticed by experienced judges or wasn't taken by counsel are of no assistance at all. But what they show, at least, is that the courts can deal summarily with bad cases without having to resort to this kind of exclusionary test. It's impossible to anticipate all future factual scenarios. And that's why, in my submission, a flexible and fact-sensitive test of the kind frequently applied to date in the case law remains the correct approach. And that's certainly preferable to a difficult inquiry into whether a particular grievance is internal or external in the way suggested by Chedington. And in my submission, the better course is to accept that the breaks have standing and then leave it to Chedington to apply for summary disposal on the merits, if the merits are as bad as Chedington consider them to be. Anticipating how this court's judgment will be interpreted in routine hearings in busy bankruptcy lists before district judges in county courts, I respectfully submit that the external-internal distinction favoured by Chedington is likely to create more heat than light in those sorts of applications. And this case presents a good example of that. The parties not only disagree that internal-external represents where the line should be drawn, but they also disagree about which side of the line this case really falls on. If I could show the court the early case of Re Sidebottom, and this is found in the Supplemental Authorities Bundle at page 316.
Sorry, page?
316.
Thank you.
Supplemental Bundle. This case is particularly interesting because it appears to be the first reported use of Section 20 of the Bankruptcy Act 1869. And it also deals with Section 71, which was the right to an appeal in bankruptcy. And the facts were that the comptroller in bankruptcy had made a report to court, and the court had chosen not to take any action against the trustee in bankruptcy consequent upon that report. And the bankrupt sought to appeal. Section 71 of the Bankruptcy Act 1869 provided that an appeal could be brought by a person aggrieved, so the same wording as found in Section 20, now found in Section 303. And the conclusion of Lord Justice James, the characterisation of a person aggrieved given by Lord Justice James at page 323, is, in my respectful submission, apt. Commences about 2/3 of the way down that page. And Lord Justice James held, but the words person aggrieved do not really mean a man who is disappointed of a benefit which he might have received if some other order had been made. A person aggrieved must be a man who has suffered a legal grievance, a man against whom a decision has been pronounced which has wrongfully deprived him of something, or wrongfully refused him something, or wrongfully affected his title to something. Now this, as I say, was dealing with section 71 of that Act, which concerned a right to appeal. So by application to section 20, one would read decision as act, omission, or decision. That characterisation of essentially a legal right, an existing right that has been adversely affected, is the right test, and it's not one that ought to be constrained by means of the internal-external distinction. Now, this case also touched on section 20, the predecessor to section 303, and it's interesting to see what their lordships said about that. Just over the page, on page 324, Lord Justice James, in refusing the bankrupt the right to appeal, holds, if there has been any misfeasance on the part of the trustee, the bankrupt or any creditor has a right under section 20 to apply to the court, not because the comptroller has made a report to the court, but because he is entitled to make his own case against the trustee. And that is really the course which ought to have been taken in the present case. And then the person who made the application would have been in the position of a litigant and would have had the right of appealing from any order which the court might have made. Lord Justice Bramwell reaches a similar conclusion. He refuses the bankrupt the right to appeal, and then at the very end of that page, he finds, I come to this conclusion the more readily because under section 20, there can be a litis contestatio raised between the bankrupt and the trustee. So this Court of Appeal decision, first addressing person aggrieved in the bankruptcy context, is actually saying you've got no right to appeal, but it doesn't matter because section 20 is your safety valve. And that's exactly the right approach, and that's the approach that I would invite the court to take in this case. Section 303(1) is the safety valve for the brakes in these circumstances.
What was the route that had been taken, sorry, in this case? It wasn't under section 20.
Yes, the comptroller had made his report to court. The court had said, we're not going to take any action on your report, Mr. Comptroller, and the bankrupt had not been happy with that and sought to appeal that decision.
I see.
And this is rather like the course taken more recently by Mr. Justice Marcus Smith in the Re Lynch case. My learned friend sought to limit that on the basis that standing was not an issue, but Mr. Justice Marcus Smith's the whole scheme of the judge's reasoning in Re Lynch was that section 303 was the proper course to take.
I'm sorry to interrupt you, but I don't quite get what you're getting out of Sidebottom. The complainants were creditors who complained that the trustee in bankruptcy had not faithfully performed his duties and had not duly observed the requirements imposed on him by the statute, rules and otherwise. Is this right? It was a complaint by the creditors as to the manner in which the trustee had conducted the bankruptcy.
Yes, my reading.
What was the nature of their complaints?
Reading from the head note, it was that he had not faithfully performed his duties and had not duly observed the requirements imposed on him by the statute, rules and otherwise.
Sorry, where are you reading?
This is page 316.
It says 316 that the controller reported, is this right, that the trustee had been guilty of a misfeasance, neglect or omission by which the estate has sustained a loss which the trustee ought to make good. So, I mean, that probably now might be a 304 case, yes, but it certainly would be classically a 303 case.
Yes, but the point...
And the creditors would have standing, no question.
Yes, my lord, my submissions on this case were based on what the bankrupt did. So the creditors complained to the comptroller.
Yeah.
The comptroller made his report based on those complaints from the creditors. The county court judge refused to make any order.
Yes.
Then, at first instance, Chief Justice Bacon.
Who was the appellant? Oh, the bankrupt, I see.
Yes. So the bankrupt was the appellant.
Oh, I see. I see.
At first instance.
I see. So the bankrupt is now picking up the cudgels, as it were.
Precisely, my lord.
I see. Yes. And I see. So they're saying he could have made application, or they, because I think there were two, could have made application under section 20, was it?
Precisely, my lord.
But the later authorities would make clear that would only be right, wouldn't it, if there was might be a surplus?
If there was a sufficient interest in the bankrupt that had been adversely affected. So on the facts of this kind of case, yes, would be the short answer.
All right. Okay.
Although slight complication comes in the modern era, because of course there is no absolute need for a bankrupt to be able to show a surplus in order to bring proceedings under section 304.
Well, I appreciate that, but that's new-ish.
But it's...
Well, anyway, it's a bit... Okay. Well, that's helpful. Thank you. I haven't quite followed what was going on.
Interesting case, my lord.
Yeah. Right. Thank you. Sorry. You were going to take us to...
Yes. The significance of all this, my lord, is distinguishing between what my learned friend Mr. Sutcliffe would regard as straightforward disposition cases, into which category he put Dodwell, and this case would perhaps be in a similar category because it's based on losses to the estate.
Yes.
And my learned friend's position is that in cases of that kind, you do need to show a surplus. And that's probably right, because that is the only way that you can show a sufficient interest that has been adversely affected. But the fault line between my learned friend and me is that we don't regard this as a dispositions case of the kind that Dodwell was. We regard this as a case where a trustee has acted beyond powers and for improper purposes, targeting us, and our existing right has been adversely affected by that process. So it's not that category of case at all. And if the court is with me that we're not in that category, then the fact that I can't show a surplus is neither here nor there. And in my submission, the internal-external distinction favoured by Mr. Sutcliffe falls away. And what we need to show instead is an existing interest, a substantial interest that has been adversely affected.
Yes.
Indeed, my learned friend said this morning, just to sort of underline that point, my learned friend said this morning that other forms of maladministration may not require a surplus as a prerequisite. In non-disposition cases, a bankrupt may be able to show an interest in some other way. This is not a non-disposition case. The relevant relief is entirely about the disposition of the cottage. And so that's the proposition advanced by my learned friend that I reject. We are not in the category of a straightforward misfeat of disposition, you've caused a loss to the estate sort of case.
It's somewhat counterintuitive to think, though, that if the principal distinction between a disposition case causing loss to the estate in this case is that what the bank trustee did didn't cause any loss to the estate, then somehow the bankrupt should have a wider standing than otherwise.
But it caused harm to us.
Well, just to the bankrupt?
It interfered with an existing right that we had.
Just applying your test, suppose the trustee in bankruptcy is in possession of property that's vested in him as a result of the bankruptcy, and causes or allows to be called a nuisance to a neighbouring owner who's otherwise a stranger to the bankruptcy, except he's the next door neighbour of the trustee in bankrupt. in bankruptcy in possession, he would suffer injury to an existing right of his. How would your test, maybe you wouldn't, prevent the neighbouring owner applying under Section 303 rather than bringing a nuisance action?
The answer to that, my lord, is that in that case it would not be a question of regulating the trustee in bankruptcy's purported exercise of his powers qua trustee.
Well, why not? He has a power qua trustee to be in possession of property that's vested in him, and the complaint would be that he failed to comply with his duty to secure the property and ensure that some noxious substance didn't escape from it across the boundary to his next door neighbour.
If he is doing it in his capacity as trustee in bankruptcy, and it's the noxious substance is escaping from an asset of the bankruptcy estate.
But he's only in possession because he's the trustee. It's vested in him because he's the trustee.
Yes. Well, it's a bankruptcy asset, and it's vested in the trustee. I don't immediately see an objection to that being dealt with within the bankruptcy proceedings.
So you would accept that on your test the next door neighbour would have standing?
I certainly don't project it out of hand. I mean, I don't see an objection to it. I don't see an objection to
it.
Well, what is the distinction in this case, you say, between this claim that you're pursuing on behalf of the Brakes personally, and the one that failed in the Court of Appeal, which is not being pursued, their claim as trustees, which was held to be outside the bankruptcy? I mean, why wasn't that misconduct by the trustee in bankruptcy and the exercise of his powers in relation to the sale of the property, which anybody dissatisfied, whatever the word is, can pursue under this section?
I just confer for a moment. Yes. As trustees of that settlement, there were no existing rights in the Brakes, that had been adversely affected. So it again comes back to this issue of it's the existing right is the possessory right over the cottage. And there wasn't an equivalent right that was held by the Brakes in their capacity as trustee.
And what was the What was the source of this possessory right? Can you? That is the right that was upheld by the Court of Appeal, or is it? Can you just explain what that right is on which you rely, that right was adversely affected?
Yes, my understanding, my lady, is that it originated in a licence from the partnership, and they'd been in possession ever since, and they had a better right than Chedington, which means they had a better right than Mr. Swift. So that is how they came into position.
But you're not relying on any legal title that they had dating back to when they bought the cottage and were registered owners of it.
They had legal title. Yes, so they were joint legal title holders.
Yes.
And they had occupied it under a licence from the partnership, is my current understanding. I'll just confer if I may. I'm told they had possession since 2011 or 2012.
This was the arrangement, wasn't it, whereby they were living in the house, but when the house was let to paying guests, they would move over to the cottage.
Yes, that's right, my lord, yes. Now, if I just, while I was on section 304, if I could pick up very briefly a submission that's made in my written case at paragraph 72, which my learned friend Mr. Sutcliffe didn't address. It's in relation to the disapplication of the need for a surplus in section 304. And Mr. Sutcliffe's suggestion is that one can discern parliamentary intention from the decision, as Mr. Sutcliffe would have it, to disapply a surplus requirement in section 304 while not making any consequential amendments to section 303. And in my respectful submission, the better explanation for the disapplication of the surplus requirement in section 304 is that it was the analogue, and indeed still is the analogue, to section 212 of the Insolvency Act, which is the corporate misfeasance provision, where the 1986 Act also disapplied a surplus requirement for a member to pursue those proceedings in circumstances where there had been such a surplus requirement in corporate insolvency dating back to Victorian times, and that's the Cavendish-Bentinck case. And I set that out at paragraph 72 of my written case. And for reasons of time, I won't go into that any further, but that is, in my submission, a much better explanation for the disapplication of the surplus requirement in section 304 than Mr. Sutcliffe's submission that it sheds any light on standing under section 303.
Well, I suppose, though, the point is that Dodwell had established that there was a surplus requirement, at any rate, where what was being challenged was the administration and dispositions by the trustee. So that was an established part of what became the 303 jurisdiction, and there is no equivalent provision as appears in section 212 to reverse Cavendish-Bentinck and in section 304. That's, I think, the point that Mr. Sutcliffe makes.
Yes, the point the way I put it in our written case is that at the time Dodwell was decided, there was no equivalent to section 304. So when one wanted to pursue a section 304 type case, which is what Dodwell really is, one had to go under the then equivalent of section 303, so section 80 of the 1914 Act.
Yes.
So it is probable, I would suggest, that when Mr. Justice Harman said what he said in the Dodwell case, he had in mind the Cavendish-Bentinck type principle, which was that a surplus was a requirement. And that's how one gets the rather emphatic nature of the decision in Dodwell. But by 1986, there's a splitting off between section 303 and section 304.
But there hadn't been a section 304.
No, there hadn't. So section 304 type cases had hitherto been brought under.
I see. All right.
Because that was the only safety valve available.
Right.
Okay. That's my submission.
Right.
Now, moving on to Lock and Stanley, I can take this quite quickly. The aggrieved party, Lock and Stanley, was both a creditor in the estate, or she claimed to be, and a defendant to the assigned claim. And the point on which that case turned is really a very different one to the ones before the court today. The point was that the interest on the part of the aggrieved party was not aligned with the class that she relied on in order to ground standing. So she sought to rely on her status as a creditor in order to ground standing to complain about the assignment. But as a creditor, she would be benefited by the assignment of the claim because it was the only way there would be any realisations in the estate. And she couldn't be heard to complain as a defendant because she was relying on her status as a creditor, and her status as defendant was adverse to her status as creditor. So, put another way, the complainant in Lock and Stanley did not have a substantial right that had been adversely affected by the liquidator's actions. So it can be explained on that basis.
Well, it can be, but that's not how it was explained, is it?
Well, it's in my respect.
You just described it as being explained on the basis that she was, although in fact a creditor, she was really pursuing a claim hostile to the interests of the estate as an intended defendant to proceedings by the liquidator or trustee in bankruptcy.
Yes, so she had the status she relied on, which was the status of creditor, she had no interest as creditor.
No.
That had been adversely affected by anything the liquidator did.
Sure.
So that's my submission, my lord, is that she...
Why did she have to rely on that status?
In order to grandstanding,
Yes.
or to attempt grandstanding under the statutory gateway that applies in liquidation, which is section 168(5). So in the same way that the Brakes rely on their sort of nominal status as bankrupts in order to get through the statutory gateway, the aggrieved party in Lock and Stanley relied on her status as a creditor in order to get through that gateway. But
Does section 168 not have the sort of
any other person?
sweep-up words, any other person?
it's section 168(5) is all sweep-up words, if memory serves, but it's been interpreted in the case law as being shorthand for... if I might just have a moment to turn this up, my lady. Yes, so it says, if any person is aggrieved by an act or decision of the liquidator, that person may apply to the court, and the court may confirm, reverse, or modify the act or decision, and so on. But it's been held in the case law that the words "any person aggrieved" is shorthand for creditor or contributory.
So actually a narrower class than in section 303.
I think you may have stated it too narrowly.
Yes.
I think it's a contributory creditor or other person.
Yes.
Right. Well, so why did she have to rely on being a creditor then? Why couldn't she just rely on being another person aggrieved in Lock and Stanley?
Because she had in that capacity, she had no substantial right that had been adversely affected. So she had no grievance as is required by those provisions, and couldn't get through it on the basis of being aggrieved, because in order to be aggrieved, one needs to have the interest that's been adversely affected.
I mean, does your argument amount to this, that one thing that gets you in under section 303 is if you have an independent cause of action against the trustee in bankruptcy, such as in my Lord's nuisance example? I mean, you're accepting, I think, that it makes no difference whether it's the trustee who has the legal right that's infringed or somebody else. If it's somebody else here who had a possessory right to the cottage, exactly the same thing would have arisen. But what you're saying is it makes all the difference whether somebody has a legal right that is affected by what the trustee does, as opposed to not the case separately, no separate legal right, such as you say was the case with the trustees of the settlement here when they made an unsuccessful bid.
Yes, my lord. Now, if I could move on now to Mohammed and Morris. My learned friend submitted that the Mohammeds in that case had two capacities. They were both creditors and parties claiming subrogation. And in my submission, that's not right. If I could invite the court to turn to page 180 of the primary authorities bundle. And the relevant paragraph is paragraph 27, where Lord Justice Peter Gibson finds that records a submission of counsel that Miss Newman submitted that the Mohammeds were undoubtedly creditors of BCCI. That is not right. The capacity in which they bring proceedings under section 168(5) is a sureties claiming subrogation rights. As Mr. Snowden said, a surety asserting rights of subrogation is not a creditor in the liquidation of the company, but is seeking to enforce rights outside the liquidation. So that was a case decided on the quite trite point that security rights are a matter external to an insolvent estate. Now, the Walker and Kalachchi case can be explained on the same basis, and indeed should be explained on the same basis as Locke and Stanley. The complaining party did not have an existing right, a substantial right, that had been adversely affected by the liquidator's actions. And the paragraph, or rather the sentence that I'd just like to show the court, is the one identified by my Lady Rose this morning during Mr. Sutcliffe's submissions, and that's at page 221 of the primary authorities bundle. This is the third sentence on that page, where Mr. Strauss, QC, says, I agree with Mr. Moss's submissions that the operative principle is judicial restraint, that there is no doubt about the court's jurisdiction, that there is no absolute rule as to when it will be exercised, and that the court might well act to restrain reasonably anticipated impropriety, even if revealed by an unmeritorious application on the part of a person without a legitimate interest. Now, my learned friend deals with that simply by saying that the learned deputy judge was wrong in that case, but in my submission, it is absolutely right. And when there is a sufficiently serious example of an officer of the court going off the rails in the way that has happened in this case, the court should be very slow, in my submission, to dismiss it solely on grounds of standing.
So you would say the stronger the case on the merits, the less the standing requirement.
Yes, it's an evaluative judgment, and there would be the nature of the conduct. And this isn't a sort of early evaluation of the merits. This is simply that there is this is a category of case.
The more egregious the conduct alleged.
Yes.
Yes, I mean this goes to acting beyond powers and acting for improper purposes. So the trustee doing things that he simply did not have the capacity to do, and moreover targeted at the bankrupts. The foreign cases referred to by my learned friend don't, in my submission, assist him. In the first case, the Global Royalties and Brook case from Ontario, which is in the Supplemental Authorities bundle at page 480, this case in fact turned on the fact that the applicants were complete strangers to the insolvency proceedings. So at paragraph 3 on page 482, the penultimate sentence in paragraph 3 records none of the moving parties has filed a proof of claim in Brooks bankruptcy. And the
what if they're the person next door complaining of a nuisance, or the other squatter who's moved in, who's not the bankrupt?
There was, again, no effect on an existing right. That's the crux of it. And again, it's that is the point that distinguishes the Brakes case from these cases where people don't have standing. The actual approach taken by the court in this case was a very a conventional application of the words from re side bottom that I showed the court earlier on, and one sees that at paragraphs 13 and 14 on page 483. And at paragraph 17, the primary basis for the decision, this is at page 484, is exactly the case that the brakes run today. So at paragraph 17, it is held, in this case, the execution of the assignments did not wrongfully deprive the third parties of anything to which they are legally entitled, or prejudice them in respect of any legal rights they may otherwise have been entitled to assert. As strangers to the bankruptcy, they have no legitimate right to require that the trustee dispose of the assets of the estate in any particular manner. Further, as parties to the litigation, the decision of the trustee does not affect their ability to defend themselves against the allegations constituted by the causes of action. So it's a very conventional case that is consistent with the brakes position today. Now, in the Hong Kong case that Mr. Sutcliffe showed the court at page 460 of that bundle, the bankrupt had no locus in this case for essentially the same reason that the brakes did not have locus as trustees before the Court of Appeal. In this case, the bankrupt claimed to be a trustee for his son, and so the son was the beneficiary and the trustee did not have an interest. And in fact, the bankrupt did have standing under a different provision in that case, and one sees this at paragraphs 49 and 50 of page 466. The bankrupt did have locus under a provision concerning exclusion of property from the estate, so that wasn't a case where the bankrupt was simply shut out from being heard altogether. My Lords, the Hans Place case is the case that was described by Lord Justice Peter Gibson in the Mohammed and Morris case as being an exception, and this was the case where the landlord had standing. And my learned friend characterises this case as being one where the landlord was a contingent creditor. In my submission, that analysis of the case must be rejected because in order for the lease to be disclaimed, the rights under that lease must have been adverse to the liquidation. Otherwise, the disclaimer could not have been made. And the landlord's the adverse nature of the landlord's position was actually ventilated in some detail in that case. So it's not right to suggest that the standing point wasn't taken. It wasn't formally taken as a kind of strikeout point in the way it's presented in these proceedings, but there was plenty of discussion of the point, and I'd just like to show the court that. This is particularly important, I should add, because the references are actually wrong in our written case. I've got the references from the Butterworth's report, and in fact we ended up using the British Companies Cases report. So the references I'm going to give now are the correct ones. This is in the Supplemental Authorities bundle, and the first reference is at page 118.
So this is supplemental. Sorry, sort of place.
Yep.
And the passage I should like to show the court is at the top of page 118, and it's between letters A and B. And this is recording a submission of counsel for the guarantors. And if I can invite the court to read from "It was his contention" to "the lease."
Yes.
And then at page 120, the judge was sympathetic to those submissions, and one sees this between D and E. And if the court would care to read from just above letter D, if the court were exercising an original discretion, and then to the end of that paragraph.
We have this present if the court exercises an original description.
So in hearing the landlord in that case, the deputy judge was well aware of the kinds of points that were being taken against the landlord's interest. And in my submission, when Lord Justice Peter Gibson came to analyse that case in Mohammed and Morris, it's improbable that he overlooked the possibility that the landlord had been heard as creditor before describing that case as an exception, which is what it is. It's an example of the flexible, fact-contingent approach that the court should take in hearing matters of this kind, rather than the sort of knockout blow advocated by Chedington. And ultimately, my lords, we, the Brakes, are the bankrupts in these estates. We're not strangers. The trustee in bankruptcy accepted a private fee to take up the cause of a stranger with whom the Brakes were in a separate dispute, with a view to affecting the Brakes' existing rights, which happened. The court should be slow, in my submission, to put it at its lowest, to permit anyone to retain any benefit from arrangements of this kind, and it would be quite wrong for the court to strike out the Brakes or to reverse the Court of Appeal at the instance of a party such as Chedington, which is on any view more of a stranger to these estates than the Brakes are themselves. Now, I might just turn my back for a moment, my lords. Unless there is anything further, my lords, my lady, which I may assist.
Could I just try this, if I may? Just having listened to your submissions and focusing on one or two points that I think you, in the course of your submissions, you have emphasized, but please don't be too hasty to accept what I'm about to put to you. Would it be fair to say that, so far as the facts of this case are concerned, and having regard to that your clients are the bankrupts, that your proposition is that if a trustee in bankruptcy abuses his powers as trustee in a way which harms existing interests or rights of the bankrupt, then the bankrupt has standing under Section 303 to challenge those acts, whatever the source or nature of the bankrupt's rights or interests. So it's got first of all, the trustee has to have abused his powers as trustee, which you clearly allege in this case. Secondly, because this ties it to the facts of this case, it's targeted at the bankrupt, who, as you say, is not a stranger in any sense to the bankruptcy, in a way which harms interests or rights, existing interests or rights of the bankrupt, of the debtor. But it doesn't matter what the source or nature of those rights or interests is. So the fact that it's not a right that he holds qua bankrupt, but holds for some other reason, doesn't matter. I mean, as I say, don't be too hasty to accept it.
Right.
But is that a fair summation of what the submissions you've been making to us?
My immediate response to that, my lord, is that I would always be wary about laying down any sort of prescriptive formula in standing requirements arising in an insolvency, just because of the multiplicity of factual situations that can never be properly anticipated. Having said that, however, my lord, the formulation that your lordship has just set out is in accordance with our case.
I mean, I'm not saying that that's the only basis on which an application could be made under Section 303. Of course, particularly it's taking regarding the position of the debtor. But it is, as I have understood your submissions,
yes.
it is so stated a basis on which a debtor can apply under Section 303, and is indeed the basis on which you say these debtors have standing in this case.
Yes. There's really three elements to the summary proposed by your lordship. Firstly, it's the abuse of rights or abuse of powers.
Yes.
Secondly, it's the effect on an existing right.
Yes.
And thirdly, it's a repudiation of the internal-external distinction that Mr.
Well, instead of directing it to Mr. Sutcliffe's arguments, but
yes.
it's an substantive interest or right of the bankrupt,
yes.
of the debtor.
And one doesn't need to focus on whether that arises from an asset available for distribution, say,
yes.
In the sense of the basket of assets that comprise the estate. No, it doesn't. So I think where I'm getting to, my lord, is that yes, that is a fair summary of our case.
Thank you very much.
Thank you.
My lords, my lady, I think it might assist. The court was asking about the geography of the West Saxnola land and buildings. If I just hand up the first couple of pages of the judge's 283A judgment, which contains a plan in that judgment that's referred to in footnote 2 of the agreed facts on page 4. The plan is at the foot of page 113. And to assist, can I just explain what 1, 2, 3, and 4 are? 1 is the house, 2 is the cottage, and 3 and 4, although they're not, I think, contiguous, are the adjacent land. They certainly have the same title. So 1 the house, 2 the cottage, 3 and 4 the adjacent land. There are 3 preliminary submissions I need to make to correct or clarify submissions from my learned friend. The first 2 points involved collateral attacks by my learned friend on judgments which have either not been appealed or where a leave to appeal has been sought and refused. Firstly, he argued that the licence was a sham. That issue was argued fully in the eviction proceedings and rejected by the judge, not appealed to the Court of Appeal. Also, in answer to my Lady Rose's question about adverse possession, about the possessory right, the source of that was fully considered by the judge in his eviction judgment. eviction trial judgment, and what we propose to do, if we may, I'm sorry it's not in the bundles, is to send an electronic version and just refer you to the relevant paragraphs. But again, that has not been challenged.
Is that the judgment that gave rise to Lord Justice Lewison's judgment in the Court of Appeal?
Precisely.
Yeah.
The second point concerns I think it was either my Lord Briggs or maybe it was my learned friend saying what sauce for the goose is sauce for the gander. Chedington have no legitimate interest to seek to strike out this application. That issue was addressed by the judge in a decision that is in the supplemental bundle at page 59. If I could just ask you to look at that. The judgment starts at page 52.
I think by this time Mr. Kerr had picked up my goose and run with it.
I think he had, my lord.
But it's worth hearing.
Yes, page 59. And if I, in the interest of time, can I just refer you to paragraphs 21 through to 24. His Lordship then goes on to consider the Hunt and Conwy decision, but essentially he explains...
Is this a supplemental bundle or the supplemental authorities bundle?
Supplemental authorities bundle, I do apologise.
Page 59.
Page 59. And then pages 21 to 24, sorry, paragraphs 21 to 24, which goes on to page 60. And there his Lordship deals with that very issue, and the Brakes sought permission to appeal his judgment.
This is all really a forensic point because it's not contested that you have standing, and we're only concerned with whether they do.
My Lord is quite right, but in any event, Lord Justice Patton refused permission to appeal on the 12th of May 2020.
My goose point was the notion of the trustee in bankruptcy contemplating under the cooperation agreement, facilitation agreement, the making of a bankruptcy application for the purpose of clearing off all the Brakes' rights.
Well,
the question was, well, are you saying that if that's what the trustee can do against them, surely they can do the opposite?
Well, in my respectful position,
trustee.
My Lord, in my respectful position, the trustee can do that.
Yes.
I think it's under section 3032.
Seeking directions to dispose
It's seeking directions to dispose of bankruptcy property,
Yeah.
but it's in a very different category, we would say, to section 3031. Can I just then deal with Sidebottom, which you will find, if I can just refer you back to, again in the Supplemental Authorities bundle, page 324 was the passage from Lord Justice James's judgment,
Yes.
to which you referred by my learned friend, and what we glean from that is that what His Lordship said is if there had been any misfeasance on the part of the trustee in bankruptcy, the bankrupt or any creditor had a right under Section 20 to apply to the court to make his own case against the trustee in bankruptcy, and that is the course which ought to have been taken in that case. Now, what is quite apparent, if I can ask you to go back to page 317, is that this was a surplus case. Indeed, Lord Richards said by reference to Sidebottom that later cases allowed standing only if there was a surplus. Well, Sidebottom was indeed a surplus case, because if we look at the top of page 317, where it starts, and the controller reported to the court that the trustee had failed to comply with a requisition to credit the estate with a sum of £12,053, being the loss which independent controller of the estate of the bankrupt has sustained by misfeasance, neglect, or omission of the trustee. The debts of the bankrupt amounted to £2,200. The trustee had realised assets to the extent of £1,200. So if you add 1253 and 1200 together, it is in fact a surplus case. In
which case, Lord Justice James was wrong to refer to creditors, presumably.
Yes.
Right.
Yes. My Lords, can I now turn quickly to my learned friend's submissions on the nature of the allegations being made
Well, the
against
creditors still stood to benefit from up to the point where it became a surplus, isn't it?
Yes.
There was £1,000 for them to get.
My Lord is quite right.
Yeah.
The allegations against Mr. Swift, we do not dispute that the court has jurisdiction to hear those allegations. But the question on this appeal is whether the Brakes are the proper persons to invoke that jurisdiction. It's common ground on this appeal that the court applies Lord Millett's test in Deloitte to answer that question. In other words, the court assumes the allegations to be true, but then focuses exclusively on the relief being sought. The Brakes have to show they have a legitimate interest in the relief being sought. The relief sought in this case seeks to reverse or stop the trustee's dispositions of the cottage and the adjacent land to Chedington. We say the Brakes have shown no legitimate interest in such relief for the reasons I gave in opening. My learned friend is wrong to submit that if the Brakes lack standing, the trustee lacks accountability under Section 3031. The proper persons to invoke the jurisdiction of the court under Section 3031 are the creditors and the Secretary of State. Those are the persons to whom the trustee is generally accountable ever since the reforms introduced by the Bankruptcy Act 1883, as we set out in our written submissions at paragraphs 14 to 16 of Appendix 1. And
what's your answer, though, to the point, the essential point that's made against you, which is the fact, so it said that there's an existing legal right which is prejudiced by the trustee's conduct, should be treated as a legitimate interest, giving a legitimate interest for this purpose?
The answer to that, my lord, is that right is not a right that rises within the bankruptcy. It's a right that can be determined in the general law, and indeed has been in this case through the eviction proceedings. That's only the possessory right that arises by virtue of adverse possession that the bankrupts are relying on. As I said, they relied on different rights in their pleading and at first instance, and indeed in the Court of Appeal. But this is one that they've nailed their colours to the mast of for this appeal. But the persons, we say, who have standing to invoke the jurisdiction of the court in respect of these allegations are the creditors or the Secretary of State. They're the persons with the legitimate interest in the relief being sought by the Brakes, but no creditors have sought to unwind these transactions, nor have the Brakes, as far as we know, tried to enlist the help of the Secretary of State. It is not for the Brakes to step into the shoes of the creditors or the Secretary of State if those parties decline to get involved. And it has never been the law of this jurisdiction that the bankrupt can generally police the conduct of the trustee in bankruptcy. In particular, it's not for the Brakes to second-guess creditor decision-making. Creditors are generally left to make decisions for themselves, and that's a point made by the Cork report. And can I just give you the reference, which is paragraph 913 on page 292 of the primary authorities bundle. Where creditors choose not to act, only the Secretary of State can revisit that decision. That was the point of giving a greater role to the Secretary of State alongside creditors in the 1883 reforms. It would also be a mistake to suggest that there will be some denial of justice if this application is dismissed. First, as my Lord Legate observed, if there were any benefit to the estate, the Brakes could make an application under Section 304. They have chosen not to do so, no doubt because they were not interested in relief which would benefit the estate. Second, as my Lord Richards observed, the Brakes could also report Mr. Swift to the ICAEW, under whose license he practices as an insolvency practitioner, and it would then be for the ICAEW to investigate matters. Third, the Brakes can pursue a claim in the general law because their alleged legitimate interest is based on their possessory right in the cottage in the general law. Indeed, that is exactly what they have done. The existence of the eviction proceedings simply underlines why this claim does not belong in the insolvency jurisdiction. So my learned friend's submission that these allegations could only be ventilated through the Respondent's Section 303 application is simply wrong. There are other persons and other avenues through which those allegations can be and have been pursued to the extent there's any merit in them. What bankrupts cannot do, we say, is to rely on their capacity as such to establish standing in order to pursue an application for relief that only matters to them in some other capacity.
I think you're straining the edges of your time slot.
Well, my lord, in that case, can I... I'm very nearly finished. Can I just test your patience and also test the conceptual limit of the standing rule, which has been recognised in the Deloitte and Dodwell cases? We submit it's obvious there is such a conceptual limit, and let me just give you a couple of examples. Firstly, what if the Brakes had put tenants into the cottage and they had been evicted? Those tenants would have their rights under the general law, including under the Protection from Eviction Act. They would not have standing under Section 303. Or change the facts of this case and imagine the trustee in bankruptcy had decided to sell the cottage to the Brakes rather than Chedington because the Brakes had bribed the trustee, so he lost his objectivity. Chedington, as the frustrated bidder, would clearly have no standing to challenge that decision under Section 303 because Chedington's interest would be external to the bankruptcy. The position is no different on the actual facts of this case. The fact that the Brakes happen to be the bankrupts does not change the fact they are in substance pursuing external interests by this application. I think I'd better stop there.
Thank you very much, Mr. Sutton. We're grateful to both counsel and indeed all their substantial legal teams for the quality of the written and oral submissions which we've heard, and we'll take time to consider our judgment.